This FM 104.3. Good to meet you.
I'm Pacho. Okay. I'm going to say yes, Pacho.
And I say what other issues.
And so around 2 now they started prekono.
Oh, okay.
And 1 they started prekono.
So the uncle because he rebata ka kabino we be 1 minute.
Ma ono never cassette. Mami tie no, the mami tie no.
We just are rough now. It is not proper. It is not proper. You wouldn't even say near way and it's not proper. You are doing it.
Oh, uncle Kwesi. So we know tie.
Man Pratt and Pacho, mami tie.
Hey, kwajo beji mi o.
Cardinal.
Yes, Man Pratt.
Charles, the argument on the finality of Supreme Court decisions. Embrabi and you support to say. Edikan. Senya Edikan can because of the possibility of a review. A Supreme Court decision is not final because it can be reviewed. That is number one.
Review where?
By the court itself.
Yeah, so
hold on. So
Honorable Benai Pacho, me time
I can clarify because the Supreme Court decisions are not final. Because any na part BBH in yourself
Pacho de nyabotre.
It can say Supreme Court decisions.
Honorable Benai
I thought say review no ever could different place.
No, but the panel
but the same,
not the same panel.
But the same Supreme Court.
Yes, the Supreme
the
Court.
The body no is Supreme Court. Until the decisions are final.
No.
After review, no, and yes, different body by Supreme Court.
Honorable Benai Pacho,
just for education.
Me we are not about so why Pacho me time na can Mr. Why?
Now, the second point to recognize is that the Supreme Court is a creation of the Constitution. And the Supreme Court acts on behalf of the citizens of Ghana. The powers it exercises are the powers of the citizens of Ghana. Today, as we sit here, at least in terms of theory, every Ghanaian has the right to start a campaign for the review of even the Constitution which establishes the Supreme Court.
Of course. I'm not in my own coins.
Yeah, to that extent, you know, if you are not satisfied with the performance of the Supreme Court, and the Supreme Court claims that its ruling is based on law, the law itself upon which the Supreme Court makes that decision can change by citizens' agitation and campaign. In fact, in the extreme case, you know, citizens can abolish the Supreme Court. If we as citizens decide to amend the Constitution and to make the course of appeal the highest court in this country, it will be. It's a creation of the Constitution.
But there ain't a word of mouth.
No, you can organize a campaign and there are provisions for even removing entrenched clauses in the Constitution. There's no finality. There's no finality.
As far as what is concerned?
As far as the interpretation of law is concerned, there's no finality. Where does it end?
It ends at the Supreme Court.
No, it doesn't.
It does.
Because if citizens are firmly opposed to the decision of the Supreme Court, the very basis which gives the Supreme Court the power to make that determination can be removed by citizens.
But until that is done or achieved, you cannot do otherwise.
Oh. No,
because still, Kwesi said you can't say they are home, and then you quiet to infinity. Sasani go to infinity. No,
you can go to infinity.
No, you cannot. You cannot. Because so long as you live under democratic rule, the law says that Supreme Court is the highest court of the land.
Yeah.
Court no di asem na one na nya adwene a. You go back to that same Supreme Court for a review of its own earlier decision.
Fantastic.
Good. And this now review no court in your favor. What the Supreme Court has said is the law, is the new law.
I agree. But
so,
you can change that law.
You cannot change it. How do you change it?
Are you saying that the Constitution cannot be amended?
It can be amended. But I'm saying that...
Are you saying, sir, we cannot amend the Constitution such that the Supreme Court is not the final arbiter
in
these matters?
We can. But I'm saying that...
So it is not final. There's no finality
No,
to
but as far as we are concerned and as we sit now, there is a finality to it in that yen share process bi ase kra ye be ka say ye pese ye ko ekose samrenum kire say it says ye pese court we na nye the highest court of the land. And yen sa de en ba bia ye wo say si a nei de.
Second now.
Papa.
It is not different from what you are saying.
it is because for me, for my submission is that okay, me
and listen, it is to you. The Supreme Court has made a decision. That decision is the interpretation of the Constitution and its provisions as of now. So that decision is valid now. It may not be valid tomorrow because of the possibility of review. Now, if there's a review and that decision changes, it will not be valid tomorrow. Now, I'm saying that even in the case, in the instance where there's no review, or where the review affirms the earlier decision, there is still the possibility of any citizen campaigning to change the law and even to change the Constitution.
And until that
constitutional means.
And until that is done, Uncle Kwesi, you see,
until something is done, the reality is different.
But I make say yetiho ya emra ne boy nyina ho ban hwe de yakobe yo. Until say yen asoman ye baji atum. Say okay, even we cry a entrenched provision in the Constitution, yen kwa referendum, ne yen sesa no ne ade no. Until see a referendum, no outcome now base afe de Ghana for we the people have enacted these laws for ourselves, no. The answer they call referendum, no, is the law, and it is the finality to it.
Is it in opposition to what I'm saying?
Yes, it is.
No,
because for me,
no, Cardinal, it is not.
No. You are not maybe understanding what my point. They say at any point in law, under the constitutional rule, no. For my argument is that there is a finality to the law. There is a finality to the case. Until a new processes are started all over.
Is that not the same thing I'm saying?
Maybe they may say. Maybe who is saying?
You are not even understanding what I'm saying.
No,
let me explain.
No, but the Mamin say. Maybe the enemy say.
I'm trying to interpret what I said. Let me state.
No, I am not. I am just making my point clearer to you. What I am saying is that for me, what I am saying is that for me, at any point in time, there is a finality to the law.
Master, when the magistrate court makes a decision, at the point of the magistrate court having made a decision, there's a certain level of finality at the level of the magistrate court. When the case is reviewed by the circuit court or the high court, there's a new finality. When the Supreme Court reviews the case, there's a new finality. When the Supreme Court reviews its own decision, there's a new finality. And I'm saying that there can be another new finality through citizens' agitation leading to the amendment of the law or even leading to the amendment of the Constitution. There's another finality.
No. Man Pratt. Man Pratt.
How is
it no? When the Supreme Court makes a decision, is that not a finality?
That's the finality.
Okay. When the Supreme Court reviews its decision, is that not a new finality?
That is
is that not a new finality?
But it's still the Supreme Court.
Agree. Is that not a new
finality? At that level,
yes.
When the Supreme Court makes the first determination of a case before it, okay, it is assumed to be the final case
until you
invoke the original jurisdiction of that same court to go for a review.
But that's what I'm saying.
But when they do the review,
when the magistrate court makes a decision, is that not
that is why those are the lower courts. So it goes to the Supreme Court. No, that is not. It is not.
No.
Even when the Court of Appeals, even when the appeals court, when appeals court determines a matter before
the Supreme Court makes a decision,
that is final.
You can also go for an appeal.
Yes,
and that is a review.
Another body, but the same body now, the same court. It doesn't matter. It matters.
So
we're looking at the body involved.
Can't change for another finality to emerge. That's all I'm saying.
But the review is the last point.
It is not the
in
last
terms of
point
court.
because citizens have a right to amend the Constitution. Right now,
in that case, you have start afresh.
Yeah.
Okay, I'm going to my question.
Right now, for example, we read 1992 Constitution. It says that laws cannot have retroactive effect.
Very good example.
That portion of the law itself can be repealed through popular agitation, through processes that the Constitution itself.
But until then, no. Says I'm rather
until then,
so wait, I think that's something to be
until a superior court changes the decision of a magistrate court. Until a superior court changes the decision of a magistrate court, it is the final decision.
Of course, let's bring it back to
a superior court changes the decision of a high court, it is the final decision.
This FM 104.3. Good to meet